If you're involved in any sort of court action, legal proceedings, and you're the plaintiff and you have a very strong case, you need to be very, very aware of legal costs and the use of open letters to make offers to try to compromise or settle the proceedings by the defendant. There's a recent decision there by Justice Binchy in the High Court in January of 2018 and involved a case, I think it was Riley versus Neville and others, and essentially the Rileys, I think they were based in Galway. There was a dispute about the construction of a house. Now, leaving aside the circumstances of the particular case, and they're not really important, the key thing is that over a period of time the defendant tried to settle or compromise the proceedings by sending 6 open letters of offer to the plaintiff's solicitor, and none of these were accepted. None of the offers were accepted. When it came, however, then to the case being ultimately going ahead to court, it actually went on in the High Court for 11 days. And naturally, in all of these situations, costs followed the event. And that really means that the winner takes all. The winner is entitled to their costs. However, in this case, the defendants, the Neville brothers, their solicitor, argued that they had made a very open, honest, earnest effort to settle the proceedings and to save costs for everybody involved. And they referred to the 6 open letters that they sent in an attempt to try to compromise the case. And Mr. Justice Binchy actually agreed with this argument. So what he did was he awarded costs to the plaintiff up to a particular point in time. But after that point in time, they had to bear their own costs, or else costs were awarded against them in favour of the defendants. But the judge basically recognised that it's a good idea to try to compromise or settle proceedings if that's possible, and that a party who is attempting to settle proceedings and is sending open offers or open letters is clearly trying to settle the case. And in this case, Mr. Justice Binchy, as I say, only awarded costs to the plaintiff, even though they won their case, up to a specific point in time. So it's just something that you need to be aware of. You need to get good legal advice if you're involved in legal proceedings, and if there are offers coming to you and you're in a very, very strong position, even though you're in a very strong position, you really do need to consider the offers, and you do need to consider later on then the consequences of refusing reasonable offers to settle the case in terms of the cost that might be awarded later on. Hope you find this video useful. If you do, you might give it a thumbs up down below. Thanks for watching.